Welcome to today's podcast. My name is Pearlie Brewer, and I will be your host. Today's podcast guest is Nadine Wentzell. Welcome, Nadine. Glad to have you back.
Hi, Pearlie. Really good to be here. Thank you.
Today we're going to talk to Nadine about substance abuse in the workplace, fit for duty. We had a podcast a couple of weeks ago where we talked and gave a background about the topic of substance abuse. And today we want to focus specifically on fit for duty. Now, at the last podcast, Nadine, we had you talk about your background and give folks a sense of your background in the area of substance abuse. For a little bit different this time, let's start by getting you to talk a little bit about some of the requests that you get from clients across North America. You mentioned that in the last podcast that you're constantly getting calls. What exactly are people looking for in terms of advice or help or the problems or issues they have in the workplace?
Well, when I get calls from individuals, it's usually as a result of a referral from someone who I've worked with previously. So, and that's always a really nice indicator because they're almost pre-qualified. You know what I mean? So they know, usually have some idea of what I do. But I would say recently, over the last year or so, the majority of calls are when people have found themselves in a situation where they're dealing with someone who they believe has a substance use problem. And they're usually at the end of their rope. It's like the 11th hour and they don't know what to do. So I become involved from a case management perspective with regard to, I talk with them, I do like a little interview. I always offer a complimentary consultation to see if what I can provide is what they need and if there's a fit, because that has to work. So most of the time I'm getting a call from HR people. Sometimes it's safety. It could be both, but it's usually HR. And they've tried all kinds of things and they really don't know what to do. And the challenge is, as we spoke about before, there's no legislation in Canada to direct employers around what to do in circumstances like this. And employers are always worried about impinging on human rights, an individual's right to privacy. They don't want to discriminate. They know they have the due diligence. So it's all of these things that they're balancing, as well as the duty to accommodate. So the first thing I do is talk with them about the specifics of what's going on and how I can help. And then we go from there. And I have dealt with people who have a problem that's arisen maybe within the last 6 months, but in most cases, it's been ongoing for at least 2 or 3 years. So that's a lot of it. Sometimes the other types of calls I get or referrals I get are from third-party administrators, so companies that do specimen collections to do drug and alcohol testing. And what they find is that most employers don't know anything about testing. They're calling, requesting a test because someone told them they needed to from an employment perspective. They don't have any idea about all of the ins and outs, the nuances, and exactly what they need and how they need it and need to apply it and what's the most appropriate. So those are the two. And then from that, what normally happens is once we settle the immediate issue, then we work on their policy, because a policy is the foundation on which then they will have that direction going forward. And I often help them to put processes in place and have addendums to the policy that gives them a guide as to how to manage these things going forward.
Now, we talked a couple of weeks ago on substance abuse, and afterwards I was thinking about our discussion, and one topic we've heard a lot about, actually it's a product we've heard a lot about in the media, especially the last 3 or 4 years, maybe get your thoughts on, and that's the OxyContin. We certainly read so many articles and seen so many stories about people struggling with that product. What are your thoughts, and what have you seen in that area?
Oh my goodness, it's created a lot of carnage with many, many people. So I have to preface this by saying that I am not endorsing any product, any pharmaceutical company. I have no allegiance with anyone. So what I'm expressing are my opinions from my experience and my knowledge base and from conversations and education I've had from colleagues, etc. So OxyContin is actually a trade name. Contin is used to reference the delivery process for the product, and it means it's sustained release over 24 hours. That was marketed by Purdue Pharma, who's owned by the Sackler family, who is still going through numerous lawsuits around the empire that they created. Actually, I think I've referenced before a book called The Empire of Pain that's written about the 3 generations of the Sackler family, who were all physicians initially and who created this product. They knew that it was highly addictive and a huge problem. They marketed it as the opposite, as the be-all and end-all for pain. And as a result of their very aggressive marketing strategies in the U.S. and elsewhere, and the incentivization they gave to their salespeople, that's what created the problem that we have. So oxycodone is the actual drug. It's also what's in Percocet, Endocet, some of those older drugs that people may know the names of. But OxyContin is the one that's most commonly referred to because that's the brand name that most people are familiar with, and it's what created this whole disaster. And often, it's a really good pain reliever. And often when people are prescribed it, it's for legitimate medical reasons, for usually post-surgery or some sort of injury where there's an acute need for pain management. But because it is so highly addictive, it's not uncommon for people to then become dependent on the effect. They like how it makes them feel. And so then they eventually get to the point of addiction. And that's what's created so many of the problems that we have. It's just been a mess. And if you really want, if anyone's interested in having really a full background and insight into how this has been orchestrated over a period of probably 50 years, over 3 generations, that book is a very phenomenal resource and a really good read. So I can share that with you if you want to provide that to any of your members who may be interested.
Very good. So let's get in now then to today's topic, which is fit for duty, which became, I guess, really almost a bit of a buzzword in health and safety here a few years ago when marijuana was introduced in Canada, legalized in Canada.
Yes.
A lot of workplaces, a lot of fuss made about, how is this going to affect our workplace? We maybe haven't had a whole lot in place around fit for duty. Obviously now with the legalization of marijuana, we need to get something in place. So the term really took off. Now, in the case of substance abuse issues, how does a manager or the owner or the senior person in an organization know if they even have a substance abuse problem in their workplace? Someone put out the comment yesterday, what does substance abuse look like? So if you were to go into an organization or you were to talk to the most senior person that says, well, look, I haven't heard anything. I can't see how we have a problem. What would your response be?
Well, my response would be, you probably do. You just haven't seen it, or you don't know what to look for to recognize it. So there's a couple things. I've got all these things popping into my head. The first one is, I always say addiction doesn't discriminate. Anyone, if you have the predisposition, the genetic predisposition, the family history, trauma, all of those things, the brain chemistry that's different. There are multiple factors that can contribute to someone being predisposed for substance use disorder, for addiction, substance addiction, or process addiction for that matter. And sometimes, often actually, a person who has the most significant addictions will be a master at hiding it. So, we often have in our minds, I think, this picture of someone who's staggering or, behaving oddly or stumbling or just not performing. And eventually, substance use will manifest as poor performance, but that's usually when someone is well entrenched in their use of their substance. So, I've said this many times. People with substance use disorders generally are some of the brightest people I've ever met. And I'll tell you why I say that. Because when you think about it, the more an individual progresses in their use of their substance, the more there's the compulsion to use, the craving, it becomes almost uncontrollable. So that's what's going on inside. But externally, they're often trying to maintain some semblance of normalcy and hide that from everyone. So in essence, people lead a double life. And to do that takes a tremendous amount of energy. And that's what I mean when I sincerely say, people who have substance use disorders are often very, very high, much brighter than many people you would think of. We tend to think of someone who's uneducated, who is derelict, who maybe is on the street or, of a low socioeconomic background, etc. That's not the case usually at all. That may be where they end up, but that's not usually where the starting point is.
Now, if you were to go into a workplace, we had a
Mm-hmm.
discussion yesterday, and you referred to the fact that if you went into a workplace, how would you go about to try and get a feel for whether or not there are substance abuse issues in that workplace? What kind of
Well,
things would you look for? What kinds of questions would you ask?
yeah. Well, first of all, I would do a lot of observation. So I think I've shared with you that prior to doing the work I do now, I worked as a narcotic inspector for 10 years with Health Canada, which meant that I had access to workplaces that under federal regulation had authority to have purchase and distribute narcotic and controlled substances. So I was looking at everything from their record keeping to was there diversion going on, were things being sidelined in ways they shouldn't be, concerns of misuse and abuse within staff, all sorts of things. And a big part of it was regulatory inspections, et cetera, audits. So I've said to you, I think I could tell within 5 minutes, usually going in somewhere, you get like a spidey sense as to whether or not there was a problem or there was something going on. But that's something that I developed over time. Without that background, how does an employer know? Well, the most important thing is to observe what's going on and to ask questions and to just kind of be like a fly in the wall to see what's going on. The most important thing is to know your people. So know what their normal is. And then when you begin to see changes from that norm, that's when you start to really be vigilant on what you're seeing and be specific. And, it'll start often as absenteeism, or if you have shift work. These are some of the things that are pretty standard in the progression of the illness. People will choose to work night shifts or weekends when there's lower supervision or minimal to no supervision. They'll exhibit behaviors of, maybe sloppy work. Another big indicator is complaints from clients. So that's something that's not often thought about or considered, but often your clients or your people who are constituents of your work environment, people who have interactions with your people, your employees on a regular basis, they can be the best ones to inform you, look, I noticed something odd with this guy. Or often in work environments where you have contractors coming in, that's the other one. Contractors will sometimes go to a supervisor or manager and say, look, this guy is not safe or this woman is not safe. I don't want to work with them. And that's how some of those initial concerns when a use disorder has progressed will manifest. But if you generally want to know what's going on, it's important to be open, to have a health and safety approach. If as an employer take a heavy line, a heavy hand, it will drive it underground because people will be fearful of losing their jobs. If you change that perspective, or if you have that perspective of health and safety, and people understand that you legitimately want to help people who have a concern to get treatment and get back to work or stay at work, then you're going to have a very different approach. And that's why in the policy part, a voluntary disclosure component is critical, which would state that people who come forward if they have a concern before there's a positive drug test or a disciplinary matter won't be disciplined, and they'll be given a complete access to whatever they need to get healthy and return to work. And then an integral part of that, of course, is having consultants who you have as part of your resource that can do those independent determinations, because how does an employer know? They don't definitively. At some point, whatever that point is in your progression of dealing with a matter like this, there's a need to bring in an assessor who can do a comprehensive substance use disorder assessment. And so that person will do a 2 to 3 hour face-to-face assessment and make a determination as to whether or not there is a substance use disorder. And then from that, the employer has factual, definitive information on which they can go forward and go in a number of different directions as to how they want to address it.
Now, to go back to a comment you made a moment ago, have you ever seen any research relative to looking at people who might have substance abuse issues, and is there a correlation to workplace accidents?
There's nothing. Let me think how the best way to answer this. So first of all, if there's ever a situation that requires medical attention, even the medical attention doesn't always look at substance use. The only time that there would be a test done in an ER or in a hospital setting would be if it was required to treat what was going on, if there was a concern about alcohol use disorder. So from a medical perspective, that testing is not going to happen, so the employer is not going to know. And so because of that perspective, it's a medical model that people are treated from their health perspective first. I don't know that there's any evidence that there's been any studies that have reported that. I haven't seen any.
Okay.
But that's why. That's the why behind it as well.
That would be the why.
Yeah.
So, if an employer comes to you and asks you the following, what do I need to do in the hiring process, substance abuse, from a point of view of policies, procedures, training, implementation? I know this is a big one. What all should an organization have in place relative to this topic?
Okay, so first of all, you need to have a policy, because that, again, as I've said before, is your foundation. Now, and you're absolutely right, around the time of legalization, the terminology changed to fitness for duty. Before that, people had drug and alcohol policies. It doesn't matter what you call it, but, often people perceive the fitness for duty as an attempt to sort of not whitewash, but hide the fact that it really was a drug and alcohol policy. So whatever you want to call it, it's important to be open and honest that what you're really concerned about is substance use. There may be, and there's other things that can contribute to effects or impacts that may mimic impairment, but generally, people know that you're concerned about the substance use piece. So put your policy in place. And the integral part of that is, when are you doing testing? So pre-employment testing is where that would fall. And there's various methods you can use to pre-employment test. The most common one is urine, because you're looking at substance use over time. Now, I think I've said before that with a urine drug test, what you're going to get is metabolites. So that won't show you active drug, but it will show you that someone has a pattern of use over a period of time, especially with cannabis, because we've talked about that before as well. Cannabis can show the presence of cannabis metabolites, THC, can be present in your urine for up to 30 days after someone's consumed it. Now, that's on the far end, but if people are consuming high quantities on a regular basis, that's not unreasonable at all. So pre-employment testing, make sure that when you're having a promotion or a job application, that's clearly identified in it. That part of the requirement is that there will be a drug and alcohol test, for which a person obviously has to have a negative test result as a component of consideration for final employment acceptance. And then in your application, you don't have to go into the details, nor do you really in your policy about what drugs and what type of testing, what specimen, but those are operational decisions that you need to have talked about and have documented prior to the pre-employment process. You need to have a good relationship with either you're doing the collections in-house or with the company that does collections to do testing. And I also strongly recommend that if you want a result that's legally defensible, that you have a lab-based test. Many employers choose to use what's called a quick test or point of collection test, a POCT. Those tests are generally not reliable. They have, the urine POCTs have been on the market for quite some time, but it depends on what you want to get. Do you want to check a box, or do you really want to know if someone has substances on board, metabolites, that they've used substances at the levels that are the standard and the norm under the US DOT. And so the quick tests, the levels are higher, and they don't include all of the drugs that you would be concerned about. So employers, and this is what goes back to what I was talking about, employers not knowing what they don't know. Most employers aren't given this information, and they think, okay, I'm having a quick test, I've got that base covered. And that's rarely the case. There's so much that you're missing by doing a quick test versus having a lab-based analysis. So that's a lot of information. Pearlie, I don't know if that answers all of the questions that you had around that.
Well, there's obviously so many questions tied to that, but one question I'll throw out to you right away. Now, you do a lot of work in the U.S. And as well as Canada. Now, in Canada, I guess a lot of our listeners would say, what kinds of testing are you allowed to do in Canada?
Okay.
What are the regulations around testing?
Well, there again, we don't have any regulations. So we're guided by case law, and that is constantly evolving and changing. But that's why it's really important from an employer perspective to be very thoughtful about what it is you're doing and what's the goal of your testing. So testing not for the sake of testing, which I guess in and of itself is a deterrent, but you need to be more thoughtful so that you're within the lines of what's acceptable from a legal perspective. So excuse me, at work, the only two times that testing is generally accepted in a workplace would be for reasonable cause or post-incident. You had asked about incident testing. So the correlation between if there's an incident and someone had a substance on board, that's where that determination would be made, and none of that reporting ever happens. That's an easier call for most people because in their policy, there'd be a definition of what's an incident and what are the criteria around that. So what are the expectations? And another piece of that that's important is if there's a crew or if there's a shift, there's a processing line, that sometimes if there's an incident that happens, it may or may not involve that whole crew or processing line. So that whole crew may need to be tested. Those things need to be identified so that your people know that that could be something that could happen. That's an easy call to make. The reasonable cause doesn't happen all that often because the supervisors are either not trained well, or they're reluctant to make a determination that they think may get someone in trouble or fired. And that's why it's so important to go back to that foundational piece of health and safety. That overarching component is critical. And your employees will know if you really do have at heart their interests, their best interests for health and safety, or if you want to use testing as a way to fire people. I don't work with people who have that latter approach. So in the workplace, for testing for reasonable cause and post-incident, the only testing process that's really legally defensible is oral fluid because you're getting active drug. And that's lab-based oral fluid because generally action is taken on reasonable cause or post-incident situations, which are both policy violations. And to be able to support that from a legal perspective, if you're ever challenged, the lab-based analysis is essential. Pre-employment, you can choose to do urine or oral fluid or both. The person hasn't been hired yet, so generally there's a lot more flexibility there. A lot of employers do urine testing for reasonable cause and post-incident, but it won't withstand legal rigor. And most unions, if you have a unionized environment, are not in favor of urine testing. And I recommend solely oral fluid because what are you concerned about? Why are we testing? We want to know if I've got reason to believe someone's behavior is such that there's a concern about substance use, do they have something in their system at that point in time that's causing that effect? A urine test with a metabolite is not going to give you that. An oral fluid test will. Similarly with an incident, post-incident. The other time that urine testing is appropriate and completely acceptable is on return to work and follow-up, because usually as a component of that substance use disorder assessment, there will be a recommendation as to what the person needs for treatment. And then when they return to work, they have to have a negative return to work test first and then ongoing follow-up testing. Often, abstinence is a requirement of that, and that's why urine testing is so appropriate, or even reduced use. I haven't seen anywhere from a harm reduction model where there's been an acceptance of a certain level. So when you're looking for abstinence, urine testing is really appropriate because you are looking for use over time. So to Reader's Digest it. So in the workplace, reasonable cause post-incident, oral fluid testing for sure. Pre-employment, you can do both. I recommend both because then you're going to get historic and current. And, I think I've said to you before, that's often a red flag. If someone tests positive on a pre-employment test, it's like, because they were given advance notice that they were going to be tested as a requirement of their application. If they can't not use their substance long enough to go through that process and have a negative test, that's a huge red flag. And I think I've shared, I might have last time, I don't remember. I think I did, the story of working with one of my clients, and they went through this process. They had published very clearly that they're safety-sensitive work environments, safety-sensitive positions, that the testing would be a requirement. If you had a positive test, that would disqualify you. So an individual applicant went through the process. They tested positive. It was right around the time of legalization, and they were up in arms because, well, it's legal, and they're impinging on my rights, my human rights, and all of these things. And first of all, human rights, an individual and employer can only discriminate against an employee if they're discriminating against someone who has a disability. So people misinterpret that all the time. But this individual was pretty annoyed at the whole thing, and he went to the media And one of the media personnel called me because they know I do this type of work and they asked me to comment. And I said, well, first of all, I can't because they're a client. But what I can tell you in general is that when you advise someone that they have to have a negative test before they're going to be accepted as an employee if they pass everything else, and they have a positive test, that's a huge red flag. And that's exactly what this employer did. And so I remember the reporter went, oh, and I said, candidly, in my world, that's what, people will perhaps not appropriately, but colloquially refer to as the idiot test, because if you have someone that can't manage to maintain sobriety, abstinence, whatever term you want to use, then that's a really good filter for you. And I remember afterwards, the health and safety person called me and he was doing a happy dance because the media attention that garnered them basically sent a very clear message to any future applicants to that particular employment situation. So that's probably the strongest example I have around that and how effective it is. But all of those criteria need to be in place. The employer has to make it well known in advance, and they have to follow through the whole process, lab-based testing, et cetera.
Now, here in Canada, according to the courts, are you
Yes.
allowed to test before you hire?
Yes, it happens all the time.
Okay, so you are allowed to.
Now, I know that there's some discrimination not discrimination, that's the wrong word. There may be some differences of opinion on that, but I don't know of anywhere where that's not permitted. The most important thing is that be communicated in advance. So are you aware of something that I may not be in that regard, Paralee?
No, I just wondered if, I know there's been a lot of discussion. I know there have been cases that have ended up at the Supreme Court here in Canada relative to testing. And I was just curious as to whether or not you were allowed to actually pre-test in Canada. I knew what the other comments you were making. I've read about that being, very much an ongoing question, but that's what the law decided. I just wasn't sure about pre-testing.
Yes. Now, if you have a unionized environment, again, this person isn't hired yet, so the union doesn't normally have jurisdiction over someone that's not yet in the workplace. It's an applicant, as far as I know. Now, I would defer to an employment law lawyer to perhaps clarify anything specific on the extent of a union's reach, but as far as I know, that's the case. So again, the most important thing is that communication so that people know that. And honestly, it gives potential applicants more confidence. People who do not have a problem with substance use are more apt to be the type of applicants you're going to get when that is well known. And I've had situations where that's happened. I had one particular client that was known to have a significant substance use problem within the workplace. And they really wanted to do something about it. So we put a strong policy in place. We started doing pre-employment testing. We made it very obvious that we were going to do drug and alcohol testing for reasonable cause and post-incident. And so they changed their culture almost completely, like 180. It wasn't completely eradicated, but it was diminished dramatically. And they went from having they couldn't get people to work for them, to having people call up and ask, say, do you have any openings, or, are you looking for people? So that is one very strong example of where just being very fair and very consistent and vigilant did a 180 in the culture and the perspective from the community of people who wanted to work for this client.
Now, you use the term safety sensitive position.
Yes.
How would you describe that to someone who says, well, what do you mean by that? Or what is, or who would be classified as being in a safety sensitive position?
Generally, that's a determination that needs to be made by each respective employer, and you need to look at each job within your work environment. So it's the work environment, the level of risk, and it's also the job within each of those work environments. So there's a matrix that people usually work with, and it would be not that there isn't any, so there'd be green. So work environment versus work responsibilities. And then it would progress to, depending on the circumstances, potentially, and then absolutely like 100% of the time. So safety sensitive positions are generally those where there's a high risk of injury if there is if there are people who are working who have substance use concerns, any error in judgment or process, anything that I'm sorry, I'm not saying this very well. If an individual is not performing their tasks to the expected competence, that the consequences could be detrimental to the point of having fatalities. So that's generally it. There's a definition in the Canadian model that I don't have in front of me right now, but that's something I can also provide to you for your listeners if that's something they'd be interested in.
Now, one thing I didn't get to at the first of the podcast today, I want to mention, we talked about in the last podcast, and that's your medical model. Now, I want to bring that up again because, as we move into duty to accommodate and some of these other issues,
Yes.
What did you mean, and can explain to our listeners by the medical model?
So when I say that or when I use that term, I mean approaching substance use disorder for what it is. It is a substance use disorder. Many people, consciously or unconsciously, or often it's sometimes a mixture of the two, or it falls somewhere in between, are very stigmatizing and very judgmental about substance use. And there's often this delineation between legal versus illegal. And I always say your body doesn't care if the drug is legal or illegal. If it's a substance that's making you unsafe, it's a substance that's making you unsafe. So when I reference medical model, it's approaching substance use disorder from a health and safety perspective, from an illness. It is a disorder. It's not a character flaw. It's not a decision that someone makes that has a bad day or whatever. So it's looking at it from a disorder that needs to be identified and can be treated and can have someone return successfully to work, versus an employer acting in the realm of an enforcer, a policer, someone who's identifying bad things happening and wanting to terminate people. So the approaches are very, very different. And the latter, the punitive approach, is one that is not uncommon. And I found it to be very common in the U.S., and I have lots of conversations with my colleagues there about that. And I think that stems from historic perspectives of how their whole war on drugs started, and the culture that they've created over years and years of substance use. And yes, they certainly do identify it from a health and safety perspective, but their approach is generally very punitive. There's no requirement to accommodate, or most employers don't follow a duty to accommodate that I'm aware of in the States, not the ones that I've had any connection with for sure. So that's the difference.
Now, here in Canada, we'll reference that. If you discover or you determine that an employee has a substance abuse issue, what should you do? What are you required to do by law? What should you do as an organization?
Well, again, there's no legal requirement other than an employer has a duty. So this goes back to that human rights component I talked about. An employer has a duty to accommodate an individual who has a disability. And under the Federal Charter of Human Rights, substance use disorder is considered a disability. So that's where the human rights piece comes in, versus, impinging on someone's privacy with regard to whether or not they can use a substance and when they can use it. So that's why those two often get confused. So duty to accommodate. First of all, the employer needs to know whether or not someone truly has a substance use disorder. Often, if there's a test post-incident and there's a positive, if there's a quick test screen and there's a positive result, the first thing the employee will not always say, but it's not uncommon to say, I have a problem, I need help. Well, that's fine. And the employer can go through the same process that they would if someone voluntarily disclosed before that happened, but there's still going to be discipline because there was a policy violation and a positive drug test. So regardless of how that's identified, the step that's critical that most employers either aren't aware of or don't access is to have that comprehensive assessment by a substance abuse expert, because they're the only person that can say definitively whether or not an employee has a substance use disorder. And so the beauty of that is external to the employer, someone they contract independently. Often that's managed through HR, and HR people have an awful lot on their plate. They're generally not clinicians who can make those determinations. So by having someone external, it gives that arm's length. And it also gives the employee confidence that it's not being a judgment made by the employer. So it helps with that overarching non-stigmatizing, non-discriminating. And it also helps the employer because it will give them a roadmap for, does this person have substance use disorder, at what level? And it's based on the criteria that are identified in the DSM the Diagnostic and Statistical Manual for Mental Disorders. So there's solid science behind this. And those categories are mild, moderate, or severe. So that's all that will be in the report from the specialist. Yes, there's substance use disorder at whatever level. And here are the things that I recommend as the clinician, as the assessor doing the determination, what this person needs to do to get healthy and be able to come back to work. So often HR generally will make a determination that people need to go through counseling or AA or treatment or any combination of those things. One size does not fit all. So the beauty of having this independent external person is it's customized for each individual and it's cost and time effective. So, and that substance assessment will also identify return to work testing, frequency, etc., whether or not it's drugs or alcohol or both. So it really gives a very good roadmap for the employer. And what I do is often case manage that because, as you can probably appreciate, there's a lot of nuances there and it's very complicated. And what I have found and what employers and employees tell me is having that independent third-party perspective of mine. Employees will share with me things that I would not otherwise know, and employers have a sense of accountability with the employee because it's hard to manage these circumstances. I know that may sound like a shameless plug, but it's not. It's really what works, and it's time and cost effective for the employer.
Who are these third-party organizations?
So they're not generally not organizations, they're individuals. I mean, some EAP companies will promote this as something that they offer, and I'm always very cautious to encourage employers to make sure that they understand and know the credentialing of the people doing the assessment. So I have a cadre of resources that do this type of work. The specifics on the process are identified in the Canadian model, and that's what I use and what most people who are aware of this use. The specialists would be psychologists, social workers, physicians, substance abuse disorder clinicians who are very familiar with workplace health and safety, who are very familiar with the diagnostic tools to make determinations on substance use disorder, and a number of other criteria. So not all substance abuse experts, like most things, are created equal. It's important to know that you're working with someone who has the experience and has the history of doing these determinations and may even have survived or managed through any legal challenge as well.
Look, Nadine, we could obviously talk about this topic all day, but limited on time here. Maybe one final question. What are the biggest challenges you see when you look back at your experience, say, over the last decade when it comes to this issue of fit for duty? What are the biggest challenges that workplaces seem to face or struggle with?
Actually doing the work. Right? So many employers legitimately want to do the right thing, and they often feel that once they have a policy in place that that's fine. But having constant vigilance, training and educating your people. So that's critical. You know, I don't think, and of course I have an education background and I'm a education group, nerd or whatever, but it's critical to make sure that you keep the messaging consistent and that it's over an extended period of time so people understand this is a health and safety issue. And here are some of the things you need to be aware of. The education should be annually, and your supervisor training should be case-based. It should be practically based, and it should reflect what the criteria and the requirements are in your policy. Most of the time that doesn't happen. And the first question I have been asked, and most employers are asked if there's ever a legal challenge, is what education did you do? That same employer that did their 180 with regard to their approach to substance use has had me come and do education with all of their employees, generally annually, and training with their supervisors. The first question the employer asked me was, what training have you done? What education have the people had? I need to know dates, times. I said, what do you want? I can give you anything you need over the last 5 years. And that was the end of that legal case right then and there. So that's the part that employers miss. And not all training is created equal. It's really important, again, that it be customized to your workplace and to the needs of your particular constituents. So what do your supervisors need? Give them the tools that they need and give them practice opportunities, cases that are legitimate and aligned with your workplace environment so that they really feel confident, because otherwise you'll have a policy that, as I call it, won't have any legs. It won't be applied, and it's not going to be effective, period.
Look, Nadine, I'd like to thank you very much for joining us on today's podcast, reaching out to our listeners. If you have any further questions you'd like to ask, please send them to us at podcast@ssnb.ca, and we certainly will have access to Nadine down the road. And if we need to have a third podcast, we can certainly have that. Again, you can reach out to us at podcast@ssnb.ca. If you have any questions, you're looking for further resources, we'd love to hear from you. So with that, thank you again, Nadine. I appreciate you taking the time to do our 2 podcasts. And we wish everyone a safe week and a good week. And we'll see you this time next week.
Thank you, Pearlie. I appreciate the opportunity. I could go on about this obviously for hours, so I'm happy to come back in the future if there's more interest on this or some other topic related to this.
Well, thank you very much.
Take care. Thanks.